My name's Eric Hanscom. I'm the managing attorney at Intercontinental IP. We're a Carlsbad-based law firm. We do patents, trademarks, and copyrights. For over a decade now, we've been offering a variety of classes on intellectual property law and the basic business decisions that an inventor has to make when they're trying to convert an idea into a product on the shelves at a variety of locations, including adult schools and community colleges. What we're trying to do with this series of videos is to take what we offer in these classes and make it available to people across the world as opposed to available to people who live in San Diego County. So I hope you enjoy it. To follow along with this video presentation, please download the PowerPoint presentation from our website. The link will appear on your screen right now. It's www.iciplaw.com. Now that you've downloaded the PowerPoint presentation, we're ready to go. So click on the first slide, and it should begin with 35 U.S.C. 102. 35 U.S.C. 102 is one of the three laws you're going to have to overcome if you're hoping to turn your invention into a patented invention. And to summarize many pages of legalese, 35 U.S.C. 102 basically says that if you're an inventor and you publicly disclose your invention, you have a year from the time you first publicly disclose your invention till you have to have a patent application filed on it. Otherwise, your own public disclosure can count against you as something called prior art, which we're going to be covering later on. So if we have any inventors there who are watching this video and haven't publicly disclosed your invention already, my suggestion is you don't. So in other words, don't post any comments on YouTube here saying, well folks, I listened to the video and I have, this is my invention, I'm going to lay it out for you in complete detail. Does anybody have any comments on it? That'd be a really bad idea. So again, 35 U.S.C. 102, don't publicly disclose your invention. So let's start with utility patents, because for most inventors, a utility patent is the most valuable type of intellectual property they can get. What is a utility patent? Well, a utility patent is a patent that protects the function of an item, how something works. A design patent, on the other hand, protects how something looks. So with utility patents, as you can see from that particular row, they're the most expensive, they take the longest to get examined, they're most frustrating for the inventor, and they offer the best protection if you're lucky enough to get one. So with utility patents, for example, this would be something we got a utility patent on because having a nutcracker with 3 members had never been done before. Every nutcracker before it had 2 cracking members, and we all know the problems associated with a 2 cracking member nutcracker, namely when you had the nut in the middle, half the time it would go flying off one direction, and even when you cracked it, sometimes the meat would fall on the floor. With a 3-member nutcracker, on the other hand, if you put the nut in the middle, first of all, you can use 2 hands to crack it with. Second of all, you can use leverage to crack. Third, because you've got 3 cracking members, there's more of a likelihood that the nut is going to stay on the inside of the cracking surfaces. So this worked differently than any nutcracker before had worked, which is why we were able to get a utility patent on it. But in terms of what you, the inventor, need to know about utility patents, there's some unpleasant details that you have to learn about before you decide to file for utility patents. The first problem that most inventors have with utility patent applications is that they have a relatively low success rate. Now, based on a couple of recent, well, not so recent decisions, but decisions that came down in the last 3 or 4 years along with their progeny, the first one being KSR v. Teleflex, the success rate for utility patents has gone from the 70% down to around 40% and appears to be climbing back to around 50%. So half the people who file for utility patent protection don't get patented. As a result, this tends to be somewhat frustrating for the inventor. Now, you can certainly stack the odds in your favor by having a good prior art search done before you decide to file for utility patent protection. But you should know from the outset that your chances of success as of the time this video is being made, if you don't do a prior art search and just run right into this thing, are probably below 50%. So what else do you need to know about utility patents? Well, the first thing is they take a long time to be examined. Oftentimes you'll be waiting a year or two before the USPTO examiner gets around to examining your utility patent application, so that's pretty frustrating for some inventors. Why does it take so long? Well, The rapidity with which the U.S. Patent and Trademark Office examines your application is based upon a couple of factors. Now, you have to understand how the U.S. Patent and Trademark Office works. It's a series of 8 really large buildings. They all seem about 8 or 9 stories tall when you're there, and they're all full of examiners and their supervisors. Now, the examiners are grouped into groups of examiners called art units, and the goal there is to have each examiner kind of specialize in a certain type of patent application. The quickness with which they get to your patent application, or the slowness, depending on how you view it, will depend upon how many applications hit that particular art unit each month, divided by the number of examiners that are in that art unit, with kind of a confounding variable being thrown in there, the rapidity with which the examiners are hired away by law firms and have to be replaced by other examiners. So, for example, a few years ago when electrical engineers were in very short supply, it was not uncommon to go through 2, even 3 examiners on one particular software application, because you'd get a software application examiner and he or she would get hired away by Apple or Microsoft. Then you'd get another one on your case, unfortunately have to re-educate them about the patent application often. Then they get hired away, you'd probably end up getting examined by the 3rd one that you had working on your application. Now, at least as of the time of this video, we're hopefully the tail end of this wonderful recession, so law firms aren't hiring so quickly, and as a result, patent examiners tend to stay at the USPTO for longer periods of time. And as a result, you're more likely to keep the same examiner on your application. But anyway, that's the reason why it can take anywhere from 7 months up to 4 or 5 years to have your patent application examined, again, depending on the type of application it is. Now, there are ways that you can accelerate the examination or speed up the time between application time and examination time. We'll go over those later on in this course. Right now, as of the time this video is being made, simple mechanical inventions are usually examined anywhere from a year to a year and a half after you submit the application. More complex electrical and business method applications, sometimes a couple years. Software inventions, unfortunately, are still going 3 years or more in most cases. So if you have a software invention, you may want to think about going with one of the accelerated examination or the track 1 methods, whereby you can pay a little extra money and have your application examined earlier than it would be normally. What is the cost for a utility patent application? Well, usually it will run anywhere from $7,000 up to $10,000, $20,000 for the average small inventor or small business person. Obviously, if you're the patent attorney working for a huge company like Apple or IBM or Microsoft, you're probably getting paid a very good wage and just specializing in one particular type of application. So those applications are probably costing those companies considerably more. At the same time, if you're a first-time inventor and you end up with a generalist patent attorney who has experience in all of the areas of inventions, then you're probably going to pay $7,000 to $10,000 to get going. If you're lucky enough to get a utility patent, how long does it last? Well, right now, it lasts 20 years from the date of filing. Now, since I've already told you it's going to take a couple years on average before your application even gets examined, most inventors who are filing applications right now end up with right around 17 years of useful life of their patent. Now, a lot of inventors will look at that and they'll say, well, my invention is way too valuable to possibly give to the public with only 17 years of protection. For those people, I'd say a couple of things. First of all, over 50% of the money made in retail sales is made off products that are 2 years old or less. Second thing, most inventors have 5 golden years to make money off their invention. If you have an invention and you haven't made money on it in 5 years, odds are you're not going to. So keep that in mind if you're an inventor who starts thinking about not filing for patent protection because you're worried about whether you're going to get 16 and a quarter or 18 and a half years of useful life of your patent. Don't worry about that. Focus on how you're going to make money the first few years, and you're probably going to be a lot happier in the long run. So again, a lot of inventors spend way too much time worrying about the tail end of their patent, and they should be worried about the front end of their patent. Are patents renewable? No, patents are not renewable. Once they expire, they expire. And anybody, again, can make or use that invention or sell it. So because they're not renewable, again, way too many inventors worry about not being able to renew the patent after 17 or 20 or whatever years, and instead they spend less time than they should worrying about how am I going to make money the first couple years off this thing. The other thing to keep in mind is that once a patent expires, it becomes public domain. Anybody can make or use that invention. So in theory, if you wanted to, you could get on the U.S. Patent and Trademark Office website and look for all the patents that are going to expire tomorrow, and you could start making those products. But nobody really does that, because by the time a patent is ready to expire naturally, odds are it's really not very valuable anymore, because what is technology? It's just improvements over prior technology. And so even if you get a utility patent on your invention and you put your invention out there and it sells a bunch, as soon as it starts selling a lot, people are going to think, well, how can I make it better? And so they are. And then your invention isn't going to be selling as much as it used to. And so probably by the time it comes for your third maintenance or renewal fee, you may be thinking twice about whether you really want to pay to have that patent be viable for a few more years.